Hi there, I'm Clifford Bates, and welcome once again to reading Montesquieu's Spirit of the Laws. We're going to play it differently today. We're going to look at this side. Maybe we'll look less than um, well, it's weird because we're having eye problems, okay? Today we're looking at the last book in part 5, which is dealing with Montesquieu's religion, right? The question of religion. Well, but it's the last book in part 5, which deals with, so far two of the books have dealt with religion, clearly about religion. And now instead we're going to be looking at and be, chapter 26 and the laws in relation they should have with the order of things upon which they are to enact. In other words, the question of okay, the laws in relation they should have with the kind of things they're about to enact, the things, order of things upon which they are to enact, right? So therefore, he then has the chapter 1 about the idea of the book, right? Idea of the book. Men are governed by various sorts of laws. So therefore, one by natural right, just by natural right, by divine right, which is that of religion, the ecclesiastical right, by ecclesiastical right, otherwise called canon law, right? Canonical, which is that of the police of religion, that of the right of nation, which can be considered as the civil right of the universe in a sense that each people is a citizen of it. Right, therefore, the rights of nations are like the idea of it's a universal civil right in that sense. By right, he means not right as a privilege, but right as a system of law, right? Uh, and which by the general political right, whose object is the human wisdom that is founded in all societies, by the particular political right, which concerns every society, by the right of conquest, founded on the fact that one people wanted, was able, or had the violence to, who had to do violence to another people. So conquest, and by civil right of each society, which allows citizens to defend his good and his life against every other citizen. And finally, domestic right, which comes from the fact that uh, uh, a society is divided into families needing a particular government. So let's look at this. This is his thing of rights, all the different types of law there is here. Natural right, that is the law of nature, the laws of nature, right? Divine right, that of religion. Ecclesiastical right, which is the religion of the church, that's the canon law, right? Which is a kind of police of the religion. That is the enforcement of the rules of religion, right? That's the third. Then the fourth is the general political right, whose object is wisdom that has founded all societies. Um, uh, um, by the particular right, so therefore the idea general political right, and then the particular human right, which concerns each society, so that this is that what's common to all. The general is what the political rights that are common, the political idea of law that is common to all versus those that are particular to it, right? Five, the right of conquest. Six, um, the civil right of each society, which is this is the laws and the things of self-defense of citizens to themselves, to self-defense and to defend their goods and their lives against other citizens, civil rights. The domestic right, which is the eighth, which is the thing with the family and the household, right? So he says, therefore, these are the different orders of law. And the sublimity of human reason consists in knowing well to which of these orders principally relate to the things on which they should enact, and in not putting confusing into the principle that should govern them. So therefore, these things he's saying here that okay, we have to know that given these things have different specific different jurisdictions and concerns and jurisdictions, And you shouldn't try to use this to do something outside his jurisdiction. This is his point. That therefore you should understand that should know well which of these orders principally relate to the things on which one should enact, and not putting confusing into the principles. In other words, okay, in this sense. Chapter 2 on divine laws and human laws. One should not enact by divine laws that which should be enacted by human laws, or regulate by human laws that which should be regulated by divine laws. So therefore, these things you should not enact by divine laws things that should be done that should be enacted by human laws, and should not regulate by human laws that should be regulated by divine laws. These two sorts of laws differ as to their origin and their object, and as to their nature. So they differ not only in terms of their origins, also as to their objects and to their natures. Everyone readily agrees that human laws are of a very different nature than that of the laws of religion. And this is a great principle. But this principle itself is subject to others which must be sought. This is one, that the nature of human laws is to be subject to all the accidents that occur and to vary as men will change, whereas the nature of the laws of religion is never to vary. Okay? So human laws vary because of condition and situation, and the religious laws don't vary; they're eternal in that sense. Human laws enact the good. The human laws enact about the good. The religion about the best. The good can have another object because there are several goods. But the best is one alone and can therefore never change. So therefore, the good can, because there's many goods, and therefore they can lead to other goods, and therefore they can change. Whereas the best is something that is best alone and can never change. Right? One can certainly change laws because they are thought to be good only by the institution of religion are always presumed to be best, but the institutions of religion are always presumed best. So therefore, in other words, one can certainly change laws because they're thought to be only good. And the good can change, right? Because based on circumstances. But religions are always presumed to be best. Two, that there are states in which the laws are nothing, or nothing but a capricious and transitory will of the sovereign. And in these states, the laws of religion were of the same nature as human laws. The laws of religion would be also nothing. However, it is necessary for society for something to be fixed, and religion is that fixed thing. So the difference between law and this, then that there needs to be something fixed. Human nature needs something fixed, and if the civil laws aren't fixed and are nothing, then religion better be there, or everything will be unfixed. Right? 3, the principal force of religion comes from it being believed. The force of human laws comes from being feared. So belief and fear, right? Antiquity is suitable. Antiquity is suitable to religion because often the most distant things are from us. The more the more we believe them. We have in our head no secondary idea drawn from those times that can contradict them. Human laws, on the other hand, gain advantage from the novelty, which show the legislature particular and present attentiveness to their observations. Okay? So therefore, the antiquity has our minds of religion. Religion gets us from antiquity because we don't have anything that contradicts them in that sense, right? There were no secondary ideas from that same times that contradict them. And human laws, however, deal with the novelty of the present, right? And the legislature's particular tend to deal with what is present. Chapter 3 on civil laws that are contrary to natural law. If a slave, says Plato, defends himself and kills a free man, he should be treated as a parasite. This is a civil law that punishes natural defense, right? And I think this is not the laws, but laws, chapter 9. But this is a civil law that punishes natural defense. Therefore, this is a civil law, and there's this contrary to this. Under Henry VIII, the law that condemned a man who had not been confronted by witnesses was contrary to natural defense. Indeed, in order to condemn, the witness must know that the man against whom they had made a disposition is the one whom they accuse. And the accused man must be able to say, I am not the man to whom you speak. A man passed during this, a law passed during the same reign condemned every girl who, having had illicit commerce with someone, did not declare this to the king before marrying the man. This violated the natural defense of modesty. It is unreasonable to require a girl to make this declaration, um, uh, 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 as to ask the man not to seek to defend his life. So therefore, these are civil laws that are contrary and unreasonable in that sense. As the law of Henry II, which condemned a girl whose child had died to death unless she had declared her pregnancy before the magistrate, is no less contrary to natural defense. It would have been enough to oblige her to inform one of her closest relatives who would see to the preservation of the child, right? Okay, so therefore, died Beth, who died, in other words, declare a pregnancy that a magistrate died, child who had died. So therefore, this is again like this, right? Against in this punishment of her natural modesty, could she make any other confession? Education has strengthened in her the idea of preserving that modesty, and such times she can scarcely retain an idea concerning the loss of life. So modesty and like this. Much has been said of the law in England that let a 7-year-old girl choose her husband. This law was outrageous in two ways. It had regard neither for the time set by nature for the maturation of the spirit, nor for the time it set for the maturation of the body. So in other words, it's neither to the body or the spirit. That they said, okay, this is like this. Among the Romans, the father could oblige their daughter to repudiate their husband, although he himself had consented to their marriage. Right? But it is against nature for divorce to be put in the hands of a third party. If divorce is in conformity with nature, it is only so when consent is given by the two parties, or but at least one of them. And when neither of them nor the other consents to it, divorce is a monster. Finally, the faculty of divorce can be given only to those who bear the discomforts of the marriage, and who sense the moment when it is their interest to make them cease. So therefore, this is the Roman thing of the power of the father. Which is a little too. It works against the nature of that. This is a principle of custom that just went too much against the rights of nature, right? It says, and also the nature of people. Chapter 4, continuation of the same subject. Gundobad, king of Burgundy, wanted the wife or the son of one who had stolen to be reduced to slavery if they did not reveal his crime. This law was against nature. How could a wife be her husband's accuser? How could a son be his father's? In order to avenge the criminal action, he ordered one that was yet more criminal. The laws of Rissusinith permitted the children of an adulterous wife or those of her husband to accuse her and to torture the house slaves. This was an iniquitous law that, in order to preserve the Moors, overturned nature, in which the Moors have their origins. Therefore, this idea that you, in order to permit the children of the adulterous wife or those of her husband to accuse her and to torture the house slaves. Right. This is iniquitous law because it's a law that's trying to preserve morals, but it violates moral. It overturns nature itself to do this, in which Moors have their origin. Right. In other words, mores arrive out of nature, the nature of people's habits, people's customs. In our theater, we watch with pleasure when a young hero shows as much horror on discovering his stepmother's crime as he had for the crime itself. In his surprise, accused, judged, and condemned, banished, and covered with infamy, He scarcely dares do more than make a few reflections on the abominable blood from which Phaedra is descended. He abandons he abandons what he holds most dear, his most tender object, all that speaks to his heart, all that can arouse his indignation, to give himself up to the vengeance of the gods, a vengeance that he had not deserved. The assent of nature causes this pleasure. The assent of nature causes pleasure. It is the sweetest of all voices. So nature itself, the assent, causes the pleasure of this, and that this is of all. In other words, we seek. What is it? Um, in our theaters, we watch with pleasure when our hero shows as much horror on discovering what is, and his surprise, and he scarcely does so more than it makes a few reflections, right, on these things. His most tender object, all speaks to his heart. In other words, and this assent of the assent of nature assent of nature cause this pleasure, right? This wonder about this, and that this is the sweetest of all voices. He says, that's interesting. That's it's why the Phaedra about a thing. Okay, this is chapter 5. A case in which one can judge by the principle of civil right by modifying the principle of natural law. Okay, right? So therefore, a case which we can judge by principle of civil right by modifying the principle of natural law. An Athenian law obliged children to feed their fathers if they had fallen into indulgence. Indigenous, that would be poor. That is what poor. Right, this is the 6 on pain of infamy. Another on pain of prison. Right. And had fallen into indigenous. It exempted those who were born of a courtesan, those whose father had exposed their modesty to infamous dealings. Plutarch Solon, right? This is again from Plutarch. And those whom he had not given a trade to earn their living. So that the children who had not, again, this is from Solon, right? This is Solon, his laws in that sense, right? That a father was obliged, at fallen indigenous, it exempted those who were born a courtesan, those who father had exposed their modesty to infamous dealings, and those not given a trade. They had not been given a trade. The law considered that in the first case, it was uncertain who the father was. He had rendered his natural obligation precarious. And in the second, he had stigmatized the life which he had given and had done the greatest evil he could do in his children by taking away their character. That in the third, he had made their life, which they found difficult to sustain, unbearable. Right. This is the law envisioned the father and the son simply as two citizens. It enacted only from from political and civil point of view. It considered that in a good republic, mores are necessary above all else. Right. In a good republic, mores are necessary. I believe that Solon law was good. In the first two cases, the one in which nature leaves the son in the ignorance of the father, and the other in which nature seems to order the son to disown him. But one cannot prove it in the third case, where the father had violated only a civil regulation. The idea of okay, saying that, but I can understand that there's no means to survive. The child has no means to prepare for the. This is where I think Montesquieu misses the point of Solon, is that they're not given a trade, and therefore, because he has no trade, he only has his body to deal, his only body, and therefore he has no means. A trade would give him means to be able to care for his father. It's just too. Only his labor of the thing is too much to rely on that sense. And I think I understand Solon's argument. I don't understand why he says, "Oh, this is too far. This goes too far," and from his principle. Chapter 6, that the orders of inheritance depend on the principles of political or civil right, and not on the principles. So the question of inheritance is a political right or civil right, not a natural right. The Vocorian's law did not permit one to appoint a woman heir, not even one's only daughter. There never was, say St. Augustine, a more unjust law. A formula of Marcouf termed impious the custom which deprived daughter of their father's inheritance. Justinian calls the right of inheritance for males to the detriment of daughters barbarous. These ideas came from regarding the rights of children to inherit from their fathers to be the consequence of natural laws, which is not. So he's saying these are the Augustine, Markov, Justinian are they're making an error assuming that these are barbarous because this is the idea of natural right. Natural law orders fathers to feed their children. It does not oblige them to make them their heirs. The division of goods, laws concerning this division, inheritance after the death of one who's made this division, is all this can be regarded by the society and consequently by political and civil laws. It is true that the political or civil law often asks that the children inherit from their fathers, but it does not always require it. So therefore, yes, he's saying that first of all, this idea that it's that natural laws that yes take care of the children, but not necessarily give them inheritance of this. This is the realm of civil law and political and civil law, and the question of who inheritance is it's to be regulated by society in that sense, right? It's a question of inheritance. Who inherits the property of the parents or the wealth of the capital? It is true that political and civil order asks children to, maybe does, but doesn't always require. The laws about fiefs, might have had reasons for giving everything to the eldest male or to the eldest relative among the males. It might have had a political. The laws about the fiefs, these territories that were given by the king or somebody, a prince. Usually, they were given had a purpose of securing the state, right? Something for the prince, and therefore there might be a reason that they give it to the males, right? And not for giving nothing to the daughters. And the laws of the Lombard might have had reasons for allowing sisters, natural children, other relatives, and in their absence, the fiscs, to rank equally with daughters. The rule in some dynasties in China was that the emperor's brother would succeed to the throne and that his children would not. If one wanted the prince to have certain amount of experience, if minorities were feared, if it were necessary to keep eunuchs from putting children successfully on the throne, such an order of inheritance could well be established. And when in certain writers, 13, what is it? Emperor Baptiste has it right. Have called these brothers usurpers. They have judged according to an idea taken from the laws of their own country. In other words, when they call them the brothers usurpers. No. This is not. According to the custom of Numia, Ozelius, the brother of Gala, inherited the kingdom, not Messallinus the son. And still today, among the Arabs of Barbary, where each village has a leader, the uncle or some other relative is chosen to inherit according to this old custom. There are purely elective monarchies, and as soon as it is clear that in order to the order of inheritance should derive from political and civil laws, it is not for them to decide which case reason wants this inheritance to be passed on to the children, and in which case the inheritance must be given to others. In other words, in monarchies, as elective as political situations, that the inheritance is derived from this, then it shouldn't be then reason should interfere about this and say it is for them to decide whether, in cases reason, this should be done and who should do. In countries where polygamy is established, the prince has many children. Their number is too large in some countries than in others. There are some states in which the upkeep of the king's children by the people would be impossible. There one has been established to establish that the king's children do not inherit, but rather his sister's children, right? A prodigious number of children would expose the state to horrible civil wars. The order of inheritance that gives the crown to the sister children, who are no more numerous than would be the children of the prince, to have a single wife, provide against their drawback. Right? This is like this. Right? There are nations where reason of state or some religious maxim have demanded that certain families should always reign. In the Indies, such is the jealousy of one's caste and the fear of not descending from it. It has been thought that in order always to have princes of war abroad, the king's oldest sister's children should always be chosen. Here's a general maxim: feeding one's children is an obligation of natural right. Giving them one's inheritance is an obligation of civil and political right. From this derives the different provisions concerning bastards in the different countries of the world. They follow civil or political laws of the country. So therefore the questions of bastardry and this is a political concern. Inheritance, the question of inheritance is a political concern, Montesquieu argues. Chapter 7. One must, I mean, and if that's the case, that there's some things of commerce and exchange and customs are civil or political constructs, then the libertarian argument collapses to a great degree. That there's no abstract nature where everything is a jurisdiction. That nature has certain jurisdictions, but even that nature's jurisdiction is limited by the social, political dimension. So therefore, civil and political right is as much a function of the market as natural reality. So therefore, this is a limit in that sense. Chapter 7. That's why I think Montesquieu, though he's a defender of commerce, his understanding of commerce is not kind of a blind marketism of say an idea of the nature of the market that seems to the forces of the market dictate. Forces of the market do play and shape actions, but they're found within the scopes of different realms of context of peoples of the larger market of forces of trade and commerce between peoples of within a community and then within certain structures that shape those communities. Chapter 7. One must not decide by the precepts of religion when those of natural law are in question. So therefore, if this is, in other words, if the issue is about, in other words, one should not use the precepts of religion when the question and thing in question is a precept of natural law. The Assyrians had a harsh fast of 50 days, which so weakens them that they cannot act for a long time. The Turks do not fail to attack them after this fast. To favor natural defense, religion ought to put some limits on these practices. The Jews were ordered to observe their Sabbath, but it was dull-witted of this nation not to defend itself when its enemies chose to attack that day. Cambyses, laying siege to Pelusium, put in his front rank a large number of animals that the Egyptians held sacred. The soldiers of the garrison dared not shoot. Who can fail to see that natural defense is a higher order than all precepts? So this is interesting. In other words, if you have to defend your life and defend your existing of your thing versus committing a blasphemy, commit the blasphemy. Chapter 8. Because the enemy will use that as a weapon against you, right? If the enemy is using your beliefs in your thing as a weapon again, don't let those beliefs uphold you. In other words, this is the idea that self-defense. There is this kind of that the right of self-defense trumps. In fact, if in other words, this harms this, then ignore this. That's the political argument. It's not a moral argument. This is the political argument. Chapter 8, that the things ruled by the principles of civil right must not be ruled by the principles of that what is called canonical right. So therefore, in other words, you cannot use canon law to justify civil law. According to the civil right of the Romans, we had a little interrupting, as you can see, the moving of the magical fan, right? You interrupted. So, chapter 8, right? According to civil right of the Romans, he who removes, this is like, according to civil right of the Romans, he who removes a private thing from the sacred site is punished only for the crime of robbery. According to canonical right, he is punished for the crime of sacrilege. Canonical right pays attention to the place, civil right to the thing, right? This is the difference between the different. But to pay attention to the place alone is to fail to reflect either on the nature and the definition of robbery or on the nature and definition of sacrilege. So therefore, you have to understand that pay attention to the thing. So therefore, according to the Roman civil rights Roman, he who moves a private thing from the sacred is punished for robbery. But according to canonical right, this is punished for sacrilege. Pays attention to the place it was done, thing being done. As a husband can ask for separation because of his wife's infidelity, the wife could formally ask for separation because of the infidelity of her husband. This usage, contrary to the provisions of Roman law, was introduced in the courts of the church, where one only intended to the max of canonical right, and indeed considering marriage only according to the purely spiritual ideas, and to its relation to the things of the next life, the violation of the same, right? But the political and civil laws of almost all peoples have, with reason, distinguished between these two things. In other words, the difference between the next things of the next life and the violation of the rights here, right? So this is the problem. The Roman law, the courts, the canon law allowed for women to make the claim, right? They have, thus, they've done here this, right? They have required a degree of restraint and of consciousness from women that did not require from men. Because the violation of modesty presupposes in women a renunciation of all virtue, because a woman is violating the laws of marriage, leaves her state of a natural dependency, because nature has marked the infidelity of women by certain signs. Besides, the bastard children of a wife belonging necessary to the husband and are husband's burden, where the bastard children of a husband belongs neither to his wife nor are her burden, in that sense, right? That, and this is how he says that this is a very interesting thing. In other words, as the husband who asked for separation of away from infidelity, he could formally ask for separation because of the infidelity. Sorry, the husband could ask for separation of the wife from infidelity. The wife could formally ask for separation of the infidelity of the husband. This usage is contrary to the provision of Roman law. Was introduced into the courts of the church, where one could attend to the maximum of canonical right. And indeed, considering marriage only according to the purity of spiritual ideas, is a violation of the same. Right? But the political and civil law of almost all people have, within reason, distinguished between these two things. He says, right, between those that deal with the goods in this life and this, according to purity and the retentions of, in other words, the purity of spiritual ideas and the relation to those things to the next life, right, and the violation of those things. That these are separate. They have okay, sorry. They have required a degree of restraint and continence from women that do not require from men. So because they see the difference. Because the violation of modesty presupposes in a woman a renunciation of all her virtues, right? Because a woman, in violating the laws of marriage, leaves her a state of natural dependency. Because nature has marked an infidelity by women by certain signs. And besides, the bastard children of a wife belong neither to the husband and are the husband's burden, belong necessity to the husband and are the husband's burden, right? The bastard children of a wife belong to the husband and on the husband burden, where the bastard children of a husband uh, uh, belong to his wife, nor are her burden. Neither belong to her wife or her burden. That's a really weird paragraph, and that's you have to think about that for a second. What is this? Why is this brought in that way? What is the purpose of this chapter? This is a weird chapter. I understand the first point, but the purpose of what is done. He's trying to make that the first usage of that, right? The nature of sacred religion, the difference of this. But then this one, he seems to kind of make the argument the opposite, that the church moderated a bad practice in this sense, but that therefore this was a natural right. But then remember, could marriage also be a civil right? That's okay. That's another thing, right? That the desire to procreate is that, but the way that this is dealt with, and the question of bastards is a political right, right? So therefore, this complicates. This is not a simple answer in that sense. Chapter 9: the things that should be ruled by the principles of civil right can rarely be ruled in principle by the laws of religion. So rarely. Okay, that's right. They can. So religious laws are more sublime. Civil laws are more extensive. So religious laws are sublime. Religious law are extensive. The laws of perfection drawn from religion have for their object the goodness of the man who observes them, more than that of the society in which he has observed. Civil laws, on the other hand, have for their purpose the goodness of man in general, more than that of the individual. So civil law deals with man in society, man in general, and then a man in society, then the individual itself. So the goodness of religion deals with the soul of the individual. That for the, in other words, religion is the goodness of the man who observes them, and the society in which they are observed, and the society, right? The person who's observing them versus the society, where the opposite is the case in that. Thus, however respectable may be the ideas which spring immediately from religion, they should not always serve as principles for civil law, because civil laws have another principle, which is the general good of society. Okay, in the Roman Republic, regulations were made in order to preserve the mores of women. These were political institutions. Okay? When the monarchy was established, they made civil laws about them, and they made them on the principle of civil government. When the Christian religion arose, the new laws that were made had less relation to the general goodness of mores than to the sanctity of marriage. There was less regard for the union of the two sexes in the civil state than the spiritual state. So the concern was the spiritual state. So the Christian religion world, the spiritual concern was more, and therefore the sanctity of marriage was more relied on this than the civil union in the civil state. At first, according to the Roman law, the husband took his wife back to his house after she had been took the husband who took his wife back to his house after she had been condemned for adultery was punished as an accomplice of her debauchery. In another spirit, Justinian ordered that the husband could take her away from the convent within 2 years. So in another spirit, they can take her away from the convent in 2 years. They put her in a convent, but then take her back. When a woman whose husband was at war, no longer received word of him, she could, as in earlier times, easily remarry, because the power to divorce was in her hands. And the laws of Constantine wanted her to wait 4 years, after which she could send the document for the divorce to the commander, and therefore, if her husband came back, he could not accuse her of adultery. But Justinian established that, however long it had been since the death of the husband's departure, she could not remarry unless she proved the death of her husband by the disposition oath of the commander. Therefore, she waited 4 years. And Justinian had viewed the indissolubility of marriage, but one could say that he had too much. In other words, he was concerned with the but one could say that he had it too much in view. He had asked for a positive proof where a negative proof sufficed. He required a very difficult thing, on an account of the fate of a man far away and exposed to many accidents. He accused a crime. He accused a crime, that is, a desertion of the husband, when it was very natural to assume his death. His laws ran counter to public good by leaving a woman unmarried. It ran a counter particular interest by exposing her to 1,000 dangers. The law of Justinian that put among the causes of divorce the consent of the husband and the wife to enter a monastery was entirely removed from the principles of civil law. So that is that the consent of this, the consent of the husband and the wife to enter the monastery was civil. This is really principle of civil law is missing. It is natural for the origin of the cause of divorce to be certain. Uh, 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 it is natural for the origin of the cause of a divorce to be in certain difficulty that one could not have foreseen before the marriage. But the desire to stay chaste could have been envisioned because the desire to stay chaste could have been envisioned because it's in ourselves. This law favors inconstancy in a state which is permanent by its nature. Okay, so it favors inconstancy, and it runs counter to the fundamental principles of divorce, which suffers the dilution of one marriage only in the expectation of another. Finally, even following along religious ideas, it succeeds only in giving victims, but not a sacrifice to God. That's a criticism of Justinian's, how Justinian handled this divorce. Put the woman in the covenant, the monastery, right? Chapter 10. What is in what case one must follow the civil law that permits, and not the religious one that forbids. So one should follow the civil law that permits something and the civil that does not. When a religion that forbids polygamy comes into a country in which it's permitted, one does not believe, speaking politically only, that the law of that country should permit a man with several wives to embrace this religion, unless the magistrate or the husband compensates the wives while returning them in some way to their civil state. Failing this, the condition would be despotic, deplorable. They would have to obey the laws and would find themselves deprived of the greatest advantages of society. Right? That's what it is. Chapter 11. That human tribunals must not be ruled by the maxims of the tribunal that regards the next life. So therefore, human tribunals must not be guided by the tribunals of the next life. The tribunal of the Inquisition, formed by the Christian monks along the idea of the tribunal of penitence, is contrary to all good police. It has met with a general protest everywhere, and it would have given way to its contradictions if these who wanted to establish it had not taken advantage of those contradictions. It was the monarchy, right? This tribunal is unbearable in all governments. In monarchy, it can only make informers and traitors. In republics, it can only form only dishonest people. In a despotic state, it is destructive. It is as destructive as the state. So therefore, this is why this idea of tribunals doing this like this. It's a continuation of the same subject. One of the abuses of this tribunal is when two persons are accused of the same crime. The one who denies it is condemned to death, and the one who confesses it avoids punishment. This is drawn from monastic ideas in which the one who denies appears to be unrepentant and damned, and the one who confesses seems to be repentant and saved. But such a distinction cannot be the concern of human tribunals. Human justice, which only sees act, has only one pact with man, that of innocence. Divine justice, which sees thoughts, has two pacts, that of innocence and repentance. So therefore, in other words, the two pacts is innocence and repentance. The divine is innocence and repentance, two pacts. So therefore, you've sinned, you can repent. The only thing the civil act has is should not be repentant. That's interesting. That maybe this is our idea that we ask that rehabilitation, repentance, right? No, you punish the act, right? Chapter 13, in which cases the laws of religion must be followed in regard to marriage, and in which cases the civil law must be followed. So, what law should be in marriage? Which should the laws of religion or the civil law be followed? As it happened in all countries and all times, that religion has occupied itself with marriages, right? So religion has always occupied itself. From the moment certain things were in regard as impure or illicit and were nevertheless necessary, religion had to be called up in order to legitimate them in one case and condemn them in the other, right? This is the idea that, in other words, that if certain things were regarded as impure or illicit, religion was either going to legitimate them or condemn them, right? On the one hand, as of all human acts, marriage is the one is one that is the most interest to society, right? Continues that marriage is the concern that most of the society. It's not a private affair. It has certainly had to be ruled by civil law. So therefore, marriage has to be governed by civil laws because it is the utmost concern for the future of the future that there be future citizens, right? All that regard the character of marriage, its forms, and its form, the way it's contracted, its fruitfulness, and all that has made every people understand that marriage is the object of a particular benediction, with it, which, as it is not always attached, as it was not always attached to it, depend on certain higher favors, above all belonging to the spring of religion. So therefore, in other words, that a certain benediction, in other words, marriage is the object of a certain benediction, benefit, right? Something which was not always attached to it. Depend on certain higher favors, above all belonging to the religion. Right? The consequence of this union, relative to goods, to reciprocal advantages, to all that is relative to the new family, the one from which it has come, and the one that it will be born. All of this concerns the civil law. As one of the great objects of marriage is to remove all the uncertainties of illegitimate unions, religion impresses on its character on it, and civil law joins theirs to it, so that it will have all the authenticity as possible. Thus, beyond the conditions demanded by religion for marriage to be valid, civil laws can still enact others. What makes civil law have this power is that these characteristics are ones that are added, not ones that are in conflict. So therefore, these are the ones that are added to it. Civil contracts to this is the laws of religion want certain ceremonies, and civil laws want consent of the fathers. In this, they ask something more, but they ask nothing that is contrary to it. Okay, so therefore, but it follows that it is for the law of religion to decide whether or not the bond will be dissolved, indissoluble. And for if the laws of religion had established an indissoluble bond, the civil laws has ruled that it, and the civil laws ruled that it can be broken. These two would be contradictory, right? But these would therefore, if these two things, if they can be contradictory. Sometimes the characteristic impressed on marriage by civil laws are not of an absolute necessity. Such are the ones that are established by laws that, instead of annulling the marriage, they have been satisfied to punish those who contradicted it. Right? Among the Romans, the Papian laws declared that marriages they prohibited unjust, and only subjected them to penalties. And the Senate Consult rendered on the discourse of the Emperor Marcus Antonius declared them null. There was no longer a marriage, a wife, a dowry, or a husband. Civil law determines according to circumstance. Sometimes it is more attractive to rectify the ills, sometimes in preventing it. So there are civil laws deals with the circumstance. Sometimes it's more intent. It is more intent to rectifying the ills. Others wanting to prevent the ills. Right. Chapter 14. In which case of marriage between relatives, one that one no, sorry, relatives must one be ruled by the laws of nature, and which cases should one be ruled by civil laws. In the matter of prohibiting marriage between relatives, it is a very delicate thing to set clearly the point at which the law of nature ceases and the laws of where civil law begins. For for this, principles must be established. The marriage of a son with his mother confuses the state of things. The son owes unlimited respect to the mother. The wife owes an unlimited respect to her husband. The marriage of a mother to her son would overturn the natural state of each of them. Then more, nature has set the time earlier for women to have children. It has set it later for men. And for the same reason, the woman ceases earlier to have faculty and the man later. If marriage between a mother and a son permitted, it would almost always happen that when the husband was able to take part in the aim of nature, the wife could no longer. This is marriage between father and daughter, like the preceding one, is repugnant to nature, but it is less repugnant because it does not have these two obstacles. What? Thus, the Tartars who can marry their daughters never marry their mothers, as we've seen in the account. So therefore, one in other words, here's the one of in other words, the laws of nature versus civil laws, right? This is the natural law. The natural law that doesn't make sense. Doesn't make really sense. The purpose of marriage would be to protect children, and therefore the mother son marrying that is kind of against natural law. This is repugnant. Daughters marrying fathers marrying daughters, but it's still that nature. It does produce can lead to a production of offspring, and therefore this is why it's in some peoples, it's barbarian peoples, it's the Tartars example can marry their daughters and never marry mothers. We see it. It has always been natural for fathers to watch over the modesty of their children, as fathers are charged with the care of settling them in life. They have had to preserve them both in both the most perfect body and at least corrupt soul. All of that can better inspire desires and more, all the more properly produces tenderness. Fathers, ever occupied in preserving the mores of their children, should be at a distance that is natural from everything that corrupt them. One says that marriage is not a corruption, but before marriage one must speak. Before marriage one must speak. One must make oneself loved. One must seduce. This seduction that should have inspired horror, right? So in other words, this before marriage could happen, you'd have to have what? Be loved, and one must seduce. In order to make oneself love, one must seduce. And this seduction should have inspired horror. Therefore, there has had to have been an insurmountable barrier between those who should educate and those who should be educated. And any sort of corruption, even for legitimate causes, had to be avoided. Why do fathers carefully deprive the company and intimacy of their daughters, to whom of their daughters, those who are to marry them? Right. In other words, why do fathers so carefully deprive of the company and intimacy of their daughters to those who are to marry them? The horror of incest between brother and sister must have come from the same source, that fathers and mothers wanted to preserve the purity of the mores of their children, and their house is enough for them to inspire their children with a horror for everything that could incline them to the union of the two sexes. The prohibition on marriage between first cousins has the same origin. The second time, in earliest times, that is, in holy times, in the ages when luxury was unknown, all the children stayed in the house and settled there. This was because a large family needed only a small house. The children of two brothers, of two first cousins, regarded as one another's brothers. Therefore, the distance in regard to marriage was the same for first cousins as for brothers and sisters. These causes are so natural and so strong and so natural that they have acted almost everywhere on earth, independent of any communication. Right? It was not the Romans who taught the Formosans that marriage with their relatives in the fourth degree was incestuous. It was not the Romans who told this to the Arabs. They did not teach it to the Maldives. But if certain people have not rejected marriage between father and their children, between sisters and brothers, it has been seen in the first book that intelligent beings do not always follow their laws, the laws of nature, I said, right? Who would have thought that religious ideas have often made men fall into these errors? If the Assyrians and the Persians married their mothers, the former did so out of religious respect for Semiramis, and the latter, because of the religion of the Zoroaster, gave preference to these marriages. If Egyptian married their sisters, this was still another frenzy of the Egyptian religion, which consecrated these marriages in honors of Isis. As the spirit of religion is to lead us to leads us to exert effort to perform great and difficult things. A thing must not be judged natural for having been consecrated by a false religion, right? The religion causes some of these things. The principles that marriage between father and children, brothers and sisters, are forbidden in order to preserve a natural modesty in the house will help us discover which marriages are forbidden by natural law and which are forbidden by civil law, right? As children live or are supposed to live in the house of their fathers, and consequently, the son-in-law with the mother-in-law, the father-in-law with the daughter-in-law, or with the daughter of his wife, marriage between them is forbidden by the laws of nature. In this case, the image has the same effect as reality, because it is the same. It has the same cause. The civil law neither can nor should permit these marriages. There are people among whom, as I have said, first cousins are regarded as brothers, because they usually live in the same house. These are some. There are among some of this usage is. Okay. There are some among whom this usage is hardly known. Among these former people, marriage between first cousins should be regarded as contrary to natural law. Among the latter, not. So they're living together like this, right? If brothers and sisters, cousins and first cousins are like living like this, with brothers and sisters, as though they're brothers and sisters, then marriage, first cousin marriage should not be permitted. But if the cousins are separated, they don't know each other, then maybe not. Okay, but the laws of nature cannot be local laws. Thus, whether these marriages are forbidden or permitted, they are permitted or forbidden by civil law according to circumstance. That's the point right there. So the usage in which brothers-in-laws and sister-in-laws live in the same house is not necessary. Therefore, marriage between them is not forbidden in order to preserve modesty in the house. And the law that permits or forbids it is not the law of nature, but a civil law which is regulated according to the circumstances that depend on the usages of each country. These are cases in which the laws depend on mores and manners. In other words, if the laws depend upon mores and manners, then the customary principles are upheld in that sense, right? That the usage where brother-in-laws and sister-in-laws that live in the same house is not necessary. Therefore, the marriage between them is not forbidden in order to preserve modesty in the household, but and that the laws that permit or forbid it is not the law of nature, but the civil law that is regulated according to the circumstances. Right? Civil laws can prohibit marriage when, by the received usages of a certain country, they are in the same circumstances as those that are prohibited by the laws of nature. Civil laws prohibit, in other words, they agree with the laws of nature, right? And they permit them when this is not the case. Civil laws can permit them when this is not the case. There are civil laws that prohibit marriage when they are prohibited by that. Okay, that's okay. But they can permit them when it's, in other words, that this is not the case, right? The prohibition made by the law of nature is invariable because it depends on the unvarying factors, the father, the mother, and the children necessarily live in the same house. But the prohibition of the civil law are accidental because they depend on the accidental circumstances. That first cousins and others live in the same house is an accident. Right? This is accidental, so therefore the civil law can say yes and no. This explains how the laws of Moses, of the Egyptians, and several other people permit marriage between brother-in-law and sister-in-law, whereas these same marriages are prohibited in other nations. So therefore, this is the Moses, Egyptians, and religion does it, right? In the Indies, where it is quite there is a quite natural reason for admitting these sorts of marriage. The uncle there is regarded as the father, and he's obliged to support and establish his nephew as if it was his own children. This comes from the character of his people, which is good and full of humanity. This law or this usage has produced an additional one. If the husband has lost his wife, he does not fail to marry her sister. If a husband has lost his wife, he does not fail to marry his sister. And this is very natural, for the new wife becomes the mother of her sister's children, and there is no unjust stepmother, right? The unjust stepmother, that's the whole fear. The idea that something tied to this. So therefore, that's why this happens the way it does. Chapter 15. That that things depend upon the principle of civil right must not be ruled by the principle of political right. So therefore, things of civil right should not be ruled by the principles of civil right. As men have renounced their natural dependence to live under political laws, so have they renounced their natural community of goods to live under civil laws. In other words, if men have renounced their natural dependencies to live under political laws, they have also renounced their natural the community of goods to live under civil laws. These first laws require liberty from them, the second property, right? So the political laws is liberty and civil laws property. What should be decided by the laws of property should not be decided by the laws of liberty, which, as have been said, is the empire of the city alone. It is a fallacy to say that the goods of the individual should yield to public good. In other words, it is a fallacy to say that the goods of individuals should yield to public good. This occurs only when it is a question of the empire of the city, that is, of liberty of the citizen. It does not occur when each question of the ownership of good becomes it is always in the public good for each. It does not occur when it is a question of ownership of the goods, because it is always in the public good for each one to preserve invariably the property given to him by civil laws. Cicero held that the agrarian law were deadly because the city was established only in order for each one to preserve his good. Right? The agrarian laws, reforms of them were kind of dangerous because it threatened private property. Let us propose as a maxim that when it is a question of public good, it is never in the public good for an individual to be deprived of his good, or even for the least part of them to be taken from him by a political law or regulation. In this case, it is necessary to observe strictly the civil law, which is the paladinium of property, in other words, the guardian, the protector of property. Thus, when public needs of an individual land one must never act according to the strictness of political laws. But this is when the civil law, which is in a mother's eyes, which with a mother's eye, considers each individual as the whole city, should triumph. So each individual as though the whole city was. In other words, the civil law is that each individual as always the whole city. This is when this should triumph. If the political magistrate wants to build some public edifice, some road, he must pay compensation. In this regard, the public is like an individual who deals with another individual. It is quite enough that the public can constrain a citizen to sell his inheritance, and that it takes away from him his greatest privilege under civil law, that he cannot be forced to alienate his goods. So therefore, you have to pay him. After the people who destroyed the Romans had abused even their conquests, the spirit of liberty called them back to that of fairness. They exercised the most barbarous rights with moderation, and if anyone doubts it, he only has to read the remarkable works of Bolimeno, who wrote about the jurisprudence of the 12th century. In his time, highways were repaired as the highways were repaired as they are today. He says that when a highway could not be restored, another was built as close as possible to the old one, but that the property owners were compensated at the expense of those who got some benefit from the road. In those days, the determination was made according to civil law. Today, it is made according to political law. So, therefore, this is the debate of this. Back then, it was civil law that did it, the privacy, the private life, and that now today it is done by political law. Chapter 16. One must not decide by the rules of civil right when it is matter to be decided by political right. So if it's a decision that is decided by political concern, civil right should not be the basis of the decision. The basis for resolving all questions will be seen if one does not confuse the rules that derive from property of the city with those that arise from the liberty of the city. So don't the property of the city versus the liberty of the city. Okay, this is civil law, so you be tied with property and the person, the things that belong to the person, and the liberty of the city. Right? It is the domain of it is the domain of the state. Is the domain of the state inalienable or not? This question should be decided not by political laws. Should be decided by political laws, not by civil law. So, is this domain of the state inalienable or not? This is decided by political law, not civil law. It should not be decided by civil law because it is necessary for there to be a domain for sustenance of the state, as it is for there to be civil laws in a state that regulate the disposition of goods. Therefore, if one alienates the domain, the state will be forced to make a new fund for another domain. But this expedient also overturns political government because by the nature of the thing, one subject will pay ever more for each domain that is established, and the sovereign will reap less. In other words, domain property is necessary and alienation is not. Okay, so therefore, in other words, the order of succession in monarchies is founded on the good of the state, which requires that this order be fixed to avoid the misfortunes, as I said, to occur in despotisms where everything is uncertain because everything is they're arbitrary. The order of succession is in the reigning family is established not for its sake, family's sake, but because of the interest of the state. For there is to be a reigning family. The law which regulates the inheritance of individuals is a civil law, which has for its purpose the interest of the individual. That is that which regulates succession to monarchy is a political law, which has for its purposes the good and preservation of the state. So that's okay. That's the difference. In other words, you have to judge by political good, not by the succession of a monarchy is different than the inheritance of property. Inheritance of rule is different from the inheritance of one's property. It follows that when the political law has established an order of succession in the state, and this order ends, it is absurd to lay a claim to the succession by virtue of civil law of whatever people it may be. In other words, political law and succession of a state. It is absurd to then claim that the succession of civil law, right? The particular society does not have to make laws for another. A particular society does not make laws for another society, right? The civil law of the Romans are no more ample than any other civil law. They did not employ them themselves when they judged the kings, and the maxims by which they judge the kings are so abominable that they must not be revived. Right, this is right. How they judge the kings are not to be revived. So, it also follows that when the political laws make a certain family renounce the succession, it is absurd to want to use. It is absurd to want to use restitutions drawn from civil law. Restitutions are within the law and can be made against those who live within the law, but they are not good for those who have been established for the sake of the law and who live for the sake of the law. It is ridiculous to claim to decide the right of kingdoms, nations, and the universe by the same maxim used to decide among individuals a right concerning a drain pipe, if I may use Cicero's expression. So this is 44. This is De Legibus. Chapter 17, certain continuation of same subject. Ostracism should be ostracism should be examined by the rules of political law and not by the rules of civil law. Far from being able to stigmatize a popular government, this usage is, on the contrary, quite apt for proving its gentleness. We would have sensed this if, in spite of exiles always being penalties among ourselves, we had been able to separate the ideas of ostracism from that of being punished. Aristotle tells us, again, I think this is Politics, Book 313, right? That everyone agrees that this practice has something human and popular about it, ostracism. If in the time and places one exercises judgment, it was not found odious. It is for us, who see things from such a distance, to think otherwise than did the accusers, the judge, and even the accused, right? There was a choices that go exile, we kill you, right? And if one pays attention to the fact that this judgment of the people filled with glory, the one against whom it was rendered, that it was when it had been accused when it had been abused by Athens by being used against a man without merit, its use ceased at that moment. Man without merit, 46. What is that? That's again, it's contrary to the spirit of legislation. This is like right. Its use ceased at that moment. One will surely see that one had, in other words, against a man without merit, its use would cease at that moment. Its usefulness would cease at that moment. One will surely see that the one has a false idea of it, and that it was a remarkable law which prevented the bad effect of a citizen's glory by heaping on new glory on him, right? In other words, a bad effect of a citizen's glory by heaping new glory on him. By chapter 18, one must examine whether the laws that appear to be contradictory are of the same order. In Rome, the husband was permitted to lend his wife to another. Plutarch tells this explicitly. It was known that Cato lent his wife to Hortensius, and Cato was not a man to violate the laws of the country. On the one hand, a husband who suffered the debauchery of his wife did not give her over to judgment, or who took her back after the condemnation was punished. These laws appear contrary, and are not. The laws permitting a Roman to lend his wife is manifestly Lacedaemonian institution, established to give republic children of a certain breeding, if I dare use this term. The purpose of the other was to preserve the mores. The first was a political idea, the second was a civil. So the Lacedaemonian was political, and then this one was you punish that because it maintained the mores, right? 19. That things that should be decided by domestic law must not be decided by civil laws. The laws of the Visigoths wanted slaves to be obliged to tie up the man and woman they surprised in adultery, and to present them to the husband and judge. A terrible law which put in the hands of these mean persons the care of public, domestic, and individual vengeance. Right? The Visigoths gave this obligation to slaves to catch the adulterers, and it gave the hands of these slaves, the mean persons, the public care of and domestic and individual vengeance. This law would be good only in the Slegos of the East, where the slave in charge of the enclosure has broken his trust as soon as the women break theirs. He checks criminals. He checks criminals. He less to have them judged than to have himself judged, and to see whether one might lose one's suspicion that he was neglected in a search into the circumstances of the act. But in countries where women are not under guard, it is senseless for civil law to subject those who govern the house to inquisition of their slaves. The Inquisition could never be at the very moment, in certain cases, a particular domestic law, and never a civil law. So the Inquisition up to putting to the question, right? In other words, going to the slaves, punishing the slaves to do this, to get this. Chapter 20. Things that belong to the right of nations must not be decided by the principles of civil law. So therefore, things that are rights of nations like this are not determined by civil law. Liberty consists primarily in not being forced to do a thing that the law does not order. And one is in this state only because one is governed by civil laws. Therefore, we are free because we live under civil laws. So liberty consists precisely in not being forced to do a thing that the law does not order. And one is in this state because one is governed by civil laws. And therefore, if we live free, it's because we live under civil laws. It follows that princes who do not live under civil laws among themselves are not free. They are governed by force. And they are continually forced or be forced. From this, it follows that treaties they have made by force are obligatory as those that may have been made willingly. We who live under civil laws are constrained to make some contracts not required by laws. We can, with the favor of the law, recover from the violence. But a prince who is always in this state of forcing or not being forced cannot complain of a treaty that violence has been made against him. And it is as if he complained of his natural state. It is as if he wanted to be a prince in regard to other princes and wanted the other princes to be citizens in regard to him. That is, as if he wanted to run counter to the nature of things. So therefore, this is you can't be governed by the contracts. The rules that govern contracts in civil law cannot be used to govern contracts in natural law. In that sense, we're law between nations, and these are purely done by force. And where force and civil right, this is force can nullify agreement. Here it doesn't. Okay, this is the problem, and maybe this is a criticism of Hobbes, who merges these two concepts in that sense. Right? Okay. Chapter 21. The things that belong to the right of nations must be decided by political law. So, in other words, right of nature must not be decided by political law. Sorry. The right of things that belong to the right of nation cannot be decided by political laws. Political laws require that every man be subject to the criminal and civil tribunals of the country to which he lives, and to the emiterations of the sovereignty. In other words, the decisions of this. Criticism or censor. The criticism and censor. The right of nation wanted princes to send ambassadors to each other, and reason drawn from the nature of things has not permitted these ambassadors to depend on the sovereigns to whom they were sent on his tribunal. Right. In other words, they can't be governed by those laws. I have been sent there, and I can't therefore make them like this. Right. They speak for the prince who sends them, and that speech should be free. No obstacle should prevent them from acting, and they can displease. They can often displease because they speak from an independent. They can often displease because they speak of an independent man. One must impute crimes. One might impute crimes to them, if they could be punished for their crimes. One might assume they had debts, if they could be seized for debts. A prince who has natural pride would speak through the mouth of a man who would have everything to fear. Right. In other words, a prince who had natural pride would speak through a man who would have everything to fear. Therefore, with regard to ambassadors, the reason drawn from the right of nations must be followed, and not those derived from political right. For if they abuse their status as representatives, this is stopped by sending them home. One can even accuse them before their master, who becomes, in a way, their judge of their accomplice, right? So therefore, you can't kill them, you don't punish, you send them home. This is the problem of ambassadors, right? This is the principle of this. They commit rape and crime, and we hope that they're going to, But then again, that's an interesting point. If the home country does not punish them, then we are perfectly right to consider that home country as guilty of that crime as they are, and we can hold action. See, maybe that's the problem with the city, the state, the city. Like we have a problem. The city of New York has a problem with all this debt. Well, their things are doing this. Well, the city of New York should send the bill to their country saying, "Your guys did this and didn't pay it." Now, the State Department doesn't like doing that because we don't want to keep the good relation. But maybe the city of New York and places that deal with these people should do it and saying, this guy committed murder. If you don't, we're going to hold your country. We will hold your country responsible, and therefore we treat this as a civil law. Murder is as much a killing of a person as a civil. So therefore, hold the country. The victims of the family should take the country to court if they're not going to punish them, and therefore take punitive damages. Seize their assets here. Seize the country's assets here. Countries have assets abroad, right? So they make business and things like this. So, you're not you killed your ambassador killed these kids. We're going to hold you. The family goes to a civil court. If they don't send their representative to defend their case, in that case, the judge will rule by default and give the right of the family to seize assets of the case. Now, of course, then maybe they'll come and defend their assets, right? They'll say, and the question then becomes, they'll defend it. And the question is, well, you didn't defend it before. Why didn't you? You ignored it. So, this will force them to come there and police the things. Okay, that's how you can do it that way. This is the way to do it. You don't punish them. You don't deal with them. But then maybe you should deal with them as this in the way that's possible. Treat it as civil. 22, the unhappy lot of the Inca Atahualpa. The principles we have established were cruelly violated by the Spanish. The Inca Atahualpa could be judged only by the right of nations. They were judged by the political and civil laws. They accused him of having put some of his subjects to death, having several wives, etc. At the height of stupidity, that was and the height of stupidity was that they did not condemn him by the political laws and civil laws of his country, but by the political and civil laws of their own. Right? This is the case of the Gasto Viguedes, the Royal Commission of that in Peru, right? Chapter 23. And when some circumstances and political laws destroy the state, decisions must be made by political laws that preserve it, which sometimes become the right of nations. Right? So therefore, circumstances that political laws destroy the state. Decisions must be made by political laws that preserve it, and sometimes this becomes the right of. So when the political law, which has established in a state certain orders of succession, become destructive to the political body for which it was made, there must be no doubt that another political law can change that order, and far from that same law being in question to the first, that it will be at bottom entirely in conformity with it, because both will depend upon this principle. The well-being of the people is the supreme law. That's the famous thing, right? This is the famous thing. The well-being of people is the supreme law. As I have said, that a great state chapter. This is, he said, that Book 5, Chapter 14, Book 8, Chapter 16, Book 9. And I think this is England, I think, right? Has become secondary to another. I said a great state has become secondary to another would be weakened, and even weaken the principal one. Right. This if a state becomes secondary to another one. It is known that the state has an interest in having its leader at home. Its public revenue should be well administered, and that its money should not go out to enrich another country. It is important for the one who should govern not to be embedded with foreign maxims. They suit less than those who are already established. Moreover, men care prodigiously for their laws and their own laws. These make the felicity of every nation. it is rare for them to be changed without great upsets and for shedding of a great shedding of blood, as is shown in the history of all countries. Right? This is the idea that their own laws, their own things, and you're going to force them to change. There'll be great upsets and great shedding of blood. It follows that if a great state has for heirs the possessor of a great state, a possessor of a great state, the former can well exclude him, because it is useful for both the state to change the order of succession. Thus, the Russian law made at the beginning of the reign of Elizabeth quite prudently ruled out any heir who possessed another monarchy. And, thus, the Portuguese law rejects any foreigner who would be called to the crown by the right of blood. But if a nation can exclude, it has, which with even stronger reason, the right to require renunciation of the throne. If it fears that a certain marriage will have consequences that could make it lose its independence or divide it, this nation will be able to require those contradicting the marriage or their offspring to renounce all their rights they would have over the other nation. Both the ones who renounce it and those in favor of whom one renounces will be the less able to complain, as the state could be made as the state could have made a law to exclude them. So therefore, this is in other words, if the state doesn't resolve it itself by their own political law, then the rights of nations, their self-defense and their security, and could force that to happen. Chapter 24, which is the penultimate chapter of here. There are regulations of a police of another order than that of the civil law. There are criminals whom the magistrate punishes. Then there are others whom he corrects. There are the former are subjects to the power of the laws. The other, its authorities. The former are withdrawn from society. The one obliges the latter. The one lives according to the rules of society. In the exercise of the police, it is the magistrate who punishes rather than the laws. In the judgment of his crime, it is the law that punishes rather than the magistrate. So law. So the police, in the exercise of police, it's the magistrate who punishes rather than law. In the judgments of crimes, it's the law that punishes it. Matters of police are things of every instant, which usually amounts to but a little. Scarcely any formalities are needed. Right? The actions of police are quick, and the actions of and the police are exerted over things that recur every day. Right? Therefore, major punishments are not proper to it. So their punishments should not be major punishments, but minor punishments. Right? It is perpetually busy with detail, and therefore great examples do not fit it. It has regulations rather than laws. So therefore, the police has regulations, rules, and guidelines of everyday things. The people who belong to it are constantly under the eyes of magistrates. Therefore, if it is the fault of the magistrate if they fall in excess, the magistrate should regulate the police in that sense, right? Thus, one must not confuse great violations of the law with simple violations of the police. These things are of a different order. So therefore, in other words, the simple violations of police are completely, great violations of the law are more problematic in that sense, right? From this, it follows that one has one has not confirmed to the nature of things in that Italian republic, Venice, where bearing firearms is punished as a capital crime, and where it is no more dangerous to make bad use of them than to bear arms. In other words, the capital crime is punishment of that is having the arms, and therefore not robbing, not killing, but having the arms. Right. Therefore, it follows that. It also follows that much praised action of the emperor, who had a baker impaled, whom he had caught engaging in fraud, is an act of a sultan who knows how to be just only by carrying justice itself to excess. So therefore, the emperor who impales a baker for fraud, that fraud should be handled by police. Small things should be handled, and there should be proportionality to this, he's saying. And therefore, the Italian things made what should have been what should be a crime, what should be a more something habit. Again, both of these are two examples. The Venice and this are extreme, something that should be handled by police and by morers and enforced by a great punishment. Chapter 25, that one must not follow the general provisions of civil right when it is a question of things that should be subjected to particular rules drawn from their own nature. Okay, so there was one must not follow the provision of civil right when it is a question of things that should be derived by their to a particular rule from the nature, so not by civil right by circumstance, but by the nature of the thing. It is a good law that all civil obligations incurred among sailors on a boat in the course of a voyage should be null. Right? Francis Pinard tells us that in his time this was not observed among the Portuguese, but it was among the French. Therefore, this idea that it's good law that civil obligation and there was that any kind of obligation in a boat during the voyage should be null. Right? People who are together only for a short time, who have no needs because the prince provided for them, who can have but one purpose, which is that of the voyage, who are no longer in society but are citizens of a ship, should not contract obligations that have been introduced only to support the burdens of civil society. In other words, the civil obligations are for the purpose of civil society. The obligation we pay debts and do things like that. The purpose is not a society. The ship is there under obligation of some kind of trip. The prince has done this. This is kind of like things here. It is in this same spirit that the laws of the Rhodesians, made for the time when one still sailed along the coast, wanted those who remained in the vessel during the storm to have the ship in the cargo, and those who abandoned it to have nothing. So that's why, in other words, they abandoned, they get nothing. But they stay in the ship, they get to keep the Rhodesians did that. What they get, those who remain in the ship during a storm to have the ship, and those and the cargo, and those who abandon it to have nothing. Right? And that's how. Now we end here on this point. This is where we end. Any comments or questions about anything that's done in this chapter, about the question about this chapter, this book, please put them below. Right. If you have any comments, questions, or issues about this, put it there. If you liked it, like it. Share it on social media. Share with a friend. If you have not subscribed. If you know someone who might be interested, get them to subscribe. Encourage others to subscribe. That's helping grow the channel. If you did, okay, now if you didn't like it, you can always say no, but then put in the comments below why you didn't like it. Put in the comments below why you didn't like it. Last, you can follow me on social media. The links are below there. The links are below. And another thing you can do is if you want to help me do what I do, you can contribute by becoming a member, join Patreon or Subscribe Star. Okay, yeah, I'm doing this anyway, so why should I do it? He's giving it for free anyways. Well, it would help. I mean, as a point, it's like I'm going to have difficulties. I might have to stop doing some videos time because I have to go away and it's going to be burdensome to do things. And I have other things to do too, so it's been kind of difficult. So, so Patreon. Another way to help is to buy one of my books listed below. And that's it. These are posted Mondays and Wednesdays. We now will have only 5 left of these, 5 more books left. And we've turned next time we see books part 6, which deals with very specific cultural histories of this. We're going into certain cases. And then we will, again on Thursdays, we do a modern political thought, which is now at this time you should be in Schmidt, and I'm contemporary, right? And then on Fridays we do a live stream. Well, that's it. Well, take care and bye-bye. See you later.